Hi, I'm Steve Carlson, and I'm going to read to you from a brief I'm going to submit to the Minnesota Supreme Court as to why Al Franken's election certificate, which was illegally issued by two Democrats, Mark Ritchie and Mark Dayton, two Marks, you might say, they illegally issued this, and now it needs to be invalidated, and he needs to be recertified by the United States Senate under the Senate's own rules and policies. And so this is the second part of the video that gets into the procedural history that occurred during this contest, and it also gets into some of the argument of why this is inimical to democracy, which I think Al Franken is supposed to be a real supporter of the First Amendment and the right to vote. And what I'm saying is that the right to vote and the vote need to be protected by following the established procedures under the United States Constitution, which it is not being. Now, this contest, which I filed with the Minnesota Supreme Court, they appointed a panel, and now I'm asking them to, again, review what's going on here and see if it follows the law. Okay, now this contest is deformed and can only be saved by voiding it. That is, notifying the Minnesota Supreme Court needs to notify the United States Senate of the illegality of the certificate issued by Minnesota and remand this case back to the panel they appointed or some kind of another appellate panel to carry out the duties of the Minnesota courts under the Constitution and Minnesota Comprehensive Congressional Election Code. And Franken has succeeded in derailing this contest. And this Supreme Court of Minnesota improperly aided Al Franken in causing this train wreck by violating the purpose of and repeatedly applying procedures inconsistent with the CCEC, Comprehensive Congressional Election Code. The panel you appointed took over from there, with the conductor, John Vandenorth, opening the trial with the actual statement, "Let's get this railroad moving." What the Constitution and CCEC require is that you, the Minnesota Supreme Court, play your proper role through election petitions and appeals of election contests to safeguard the fundamental right in the congressional elections, that is to say, the vote, through the, quote, numerous requirements to procedure and safeguard, which experience shows are necessary in order to enforce the fundamental right involved, and unquote. And this you have failed and refused to do. And this I am charging against you. I may be right, I may be wrong, but it has not been and cannot be shown that I'm wrong. And footnote here, Judge Vandenorth, the conductor, has twice now said in court that I am a passionate advocate of what I believe is true. While I agree that I am asserting positions I believe, and not merely being a sore loser in these two contests, filed first in 2012 and now 2014, I also realize that in lawyer talk he's saying I'm arguing from the heart and not from the head. However, actually, I brought to bear an argument at the March 23, 2015 hearing from the head, and it is logically and legally correct. It is based precisely on the need for the legislature to prescribe a comprehensive congressional election code, CCEC, under Section 4 of Article 1 of the Constitution, and to carry that out faithfully so that it dovetails in the right way with Section 5 of Article 1 of the Constitution. Article 1 is the one that deals with the Congress, and it talks about how the Congress is constituted. And if you don't follow it, your Congress is built on shifting sand, shall we say. Now, in particular, that part of the code, it's based on that part of the code which requires the protecting the rights of voters, and through voters, their parties, as my lead case, Anderson versus Celebrese, United States Supreme Court case from 1983, John B. Anderson, this case drives home that it's to protect those independent voters, although the Republicans and the Democrats have co-opted that Anderson case as if it was for their national parties. It is not. It is for the independent voters. So out of that footnote 9, your job under the CCEC is to review this question. And if you feel there is conflict of interest here, I suggest you go with this panel of appellate judges you already appointed. And so the question is how can you safeguard the rights of the voters? Now, the procedures followed at the panel, the railroads of this contest, and in the words of your own judge, Vandenorth, are a travesty of justice, a farcical production as worthy of Saturday Night Live as its star performer, Al Franken. And I say this with all due respect. Your role is not as judges in a congressional contest. Further, these questions about Franken's right to office are serious questions and have never been finally determined under Chapter 209, which is the contest provision for the Congress here in Minnesota. Now, these very words from Smiley, this U.S. Supreme Court case, were noted in your 2009 Pawlenty decision, Franken versus Pawlenty. Quote, these comprehensive words, which are time, place, and manner of the elections, they embrace authority to provide a complete code for congressional elections, not only as to times and places, but in relation to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In short, to enact the numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved. Now, if you just look at that list that Chief Justice Hughes in that 1932 U.S. Supreme Court case ticked off, what good does it do to count the votes, as this panel is so concerned about, and publish the election returns and make the election returns? Those are definitely important, but it's not all, because what good would it do if you did not have protection as far as notices, as far as registration of voters, as far as supervision of the voting, as far as protection of the voters? The United States Constitution, this whole CCEC, is to protect the voters. Prevention of fraud and corrupt practices, like this fast one that's being pulled by Franken and the one he tried to pull in 2009. What good would it do to count the votes? As I said in the trial, most dictators get a lot of votes. That's not the only issue. And Franken is tending towards Castro in his ideas of democracy. Now, these words that I read are from the United States Supreme Court in a case directed to you, the Minnesota Supreme Court, and you must never cease to heed them. Not only because they are from the U.S. Supreme Court to you, but they are to you as just a part of the CCEC itself, and they are necessary for every state in the Union in order to ensure, no less than Abraham Lincoln himself did, the perseverance of our nation. We cannot exist if you play politics or allow other politicians to play politics with our congressional elections. Again, Minnesota must heed the call of the Constitution and the maintenance of the Union as founded, to be governed by those whose Creator has endowed them with a capacity for self-governance. Now is the time. The contest is not about the Independence Party. It is also not about who got the highest number of votes legally cast. The contest is about the validity of the elections, in this Senate election, and how it impacted the validity of all the statewide contests involving the Independence Party. And from the invalidity of the U.S. Senate election and the behavior of the DFL party in that invalid election, two inferences flow. One is whether due to serious, material, and deliberate violation of the CCEC, founded on Section 4, invalidating the election, Al Franken still has a right to office based on that very election. This violation is not limited to Franken only, but extends to this court, to the DFL party, to the Secretary of State, and now to Governor Dayton. Does Franken have a right to office when he grabs an illegal election certificate, runs up to the Hill, and is seated on the basis of clear violations of the Congressional Contest Provision 209.12 and of 204C.40 Subdivision 2? The other inference is, yes, the vote count, not only of my Senate race, but also all the other statewide Independent Party races, including one for Secretary of State, which reached 4.91%, just shy of 5%. And the inference there is, had the civil rights of the voters associated in the Independence Party and its nominees, including me, been protected and enforced in this invalid election, would the vote have been so affected as to retain major party status under the CCEC for that Independence Party? And second, can this status be lost in an invalid election? And I have stated my intent to seek the presidency through a statewide primary election of the Independence Party in Minnesota in 2016, and then the general election, where I will seek to get more than enough votes to carry the Independence Party forward as against Hillary Clinton or whomever the major national parties may put up there. And I would like to do this across the nation, and I would like people to run against me. Jesse Ventura has said he wants to run, but I think he wants to run by getting the Libertarian Party endorsement. And so this is not moot. And the Senate needed to have the opportunity on January 6th to make an independent decision on the validity of this election under 209.12, but was frustrated by this deformed contest that Franken created, a kind of Frankenstein, I suppose. The central issue, contrary to the panel order, is not the vote count, but the vote. The central issue is the validity of the election, which is necessary to honor all those votes. In citing all these numbers, as Franken and Ritchie did from the beginning, and as the panel cites over and over, is to derogate the core issue of the validity of the elections, just as Franken's direct appeal to your Chief Justice, Gildea, which was granted outside of the proceedings of the panel, was an attempt to detract from the core issue, the validity of the elections. I filed a notice of election contest under 209.12 concerning the U.S. Senate race December 2nd, 2014 in Ramsey County District Court. No action was taken by the Supreme Court, and they immediately had to send it to the Supreme Court, who got it right away. They actually called them while I was down there trying to get them to take it without charging me $350 or whatever, $400. Now, no action was taken by the Supreme Court until December 9th, a whole week, with this supposed haste requirement now proposed by your panel. On December 8th, 2014, Ritchie filed and served an answer, and Franken sent a request to dismiss the election contest notice to Minnesota Chief Justice Lori Sheridan Gildea. He sent it straight to you, to the Supreme Court. Now, this was completely improper by Al Franken, but the Chief Justice said nothing of the sort. But instead, she sent this motion to the panel to be adjudicated. And what this motion was to dismiss the whole thing on the grounds that Minnesota courts have no right to adjudicate this. This was basically the same argument Franken tried against Coleman in the contest, when he challenged the contest in a petition. A petition was brought about the contest, and the petition was to the same Minnesota Supreme Court. Now, while the panel contends Franken, quote, Franken also filed a motion to dismiss the notice of contest in district court, unquote, that is untrue. Because Franken took this totally inappropriate action, clearly inconsistent with Chapter 209, to the panel only because the Supreme Court, I believe through its commissioner, contacted Franken's counsel and told them to file it there, in writing. This is a letter that I've seen. Now, it was referred there by you, and it was totally improper. The panel treated it as if it were from you. Here's where you start acting like judges of the contest, not as if you were carrying out specific functions only, because the legislature, as mere agents of the framers and the people of Minnesota, assigned these roles to you, and it never stops. It's another footnote. The entire state contest proceedings is not, as the Supreme Court erroneously asserts, part of the general election laws of Minnesota. And therefore, the cases cited by the panel, a Supreme Court appointed panel, as purported precedents in a congressional contest are not apropos. For instance, in its purpose of congressional elections contest section, the panel maintains that cases about bonding issues in school districts or villages, all state matters clearly, establish parameters of a U.S. constitutionally mandated congressional contest under Section 4, and establishing its purpose and decisiveness. This is clearly erroneous because you do not decide. You aid the Senate. And what this means is that any kind of election law that's passed by the, regardless of some village in Minnesota, is all of a sudden it's seen as an amendment to this congressional election code, which is put together under Article 1, Section 4 of the United States Constitution. There's no connection. What this is, what Section 4 establishes is a layer above the state that actually is an appendage to the federal government. And it's a mere agent to aid in the selection of the federal officials, just like redistricting congressional districts can't be interfered with by Mark Ritchie or Governor Dayton, or any governor or secretary of state, or anyone except that legislature when it acts. So, but they're acting as if it's all this hodgepodge of state election law, which it is not. Okay, the Minnesota Supreme Court assigned this matter to this three-judge panel by order dated December 9, 2014. On December 11th, they then issued this order establishing this. Now, then, and I got to jump around. Okay, now had I not served Ritchie, because here's the issue, they're trying to argue that if Mark Ritchie withdraws as a party, the whole independence party question is off the ballot. The whole question of the validity of the election of Al Franken, which is what this challenge is off the docket. Why? Well, had I not served Ritchie as a contestee, which has to be done when it's a statewide question, doesn't say ballot question, just one voted on. I suppose you vote on a ballot, but it isn't clear whether voting for a senator or all the statewide races and then not meeting the 5% can be looked at, and I think it should be, as a vote on the question of the continuance of the major party status of the Independence Party. But had I not served him as a contestee, as well as furnishing the very same notice to him as the Secretary of State, as I'm required to do by the contest provisions, so I just give him one notice to Nathan Hartshorn of the Attorney General's office for Mark Ritchie. That's how you serve Mark Ritchie. You serve the Attorney General. And I gave him one notice, and I said, I'm both serving this on you as a contestee of a question voted on statewide, and I'm also furnishing you, as I'm required to do because this contest is against Al Franken as a contestee as well. Now, had I not done this, Ritchie could have said the opposite. Well, Carlson didn't serve me. He just furnished me. And so the issue he raises, which must be raised as a statewide vote question, cannot be raised as the time is now past. Now, to ensure against this, I named him and served him with it. But there can be no doubt that the question was raised in the contest, whether or not it is seen as a question voted on statewide, as either a direct vote or an inference from the Senate vote and other races affected by that vote and by the Senate race itself. It is, in the contest, question of the Independence Party's major party status, whether it can be lost out of this. Now, on December 17, 2014, Carlson filed a motion to amend his notice of election contest. The parties appeared before the panel on December 18, 2014. The panel granted Carlson's motion to amend his notice of contest without objection of either contestee. Here he refers to Ritchie as a contestee at that point. Now, and as I say, neither from Ritchie or from as a contestee or as a respondent did anybody object. Now, the panel heard Franken's motion to dismiss as amended and Ritchie's response to the request. That's sort of like a I don't know, the shuck and jive or maybe the flea flicker in football. But they had a response and request, which I think is highly unusual, to be dismissed from the contest. And the panel seems to act, and this court seems to act. And I suppose they did the response and request because if he would have made a motion, he could have been said that he made an appearance or whatever lawyers do. They're not supposed to be doing that or acting as judges in this contest. They're just supposed to be collecting the evidence on the serious questions raised, send them to the Senate. That's it. But that's not good enough for all of these lawyers and judges who want to play some role in shaping the outcome of this campaign and contest. And the panel seems to act, and this court seems to act, Minnesota Supreme Court, as this dismissal, as if this dismissal as contestee while remaining on as a respondent for the state, Mark Ritchie, ended all the questions regarding the validity of the election, which are at the core of the contest, and thus the court has never finally determined the matter under 209. Finally, the panel conducted a court trial on Carlson's amended election contest notice. In his amended notice of contest and at the trial, Carlson did not directly challenge the vote count for the office of senator, but stated that he considers it to be distorted by misconduct. Carlson testified at trial, arguing that limited access to voter email information, exclusion from debate events, and certain DFL party caucus rules resulted in low vote totals for Independence Party candidates. You left out, I say they left out the judicial review and functions under the prescribed code of the Supreme Court and the panel to entertain election petitions and election contests when necessary to enforce the comprehensive congressional election code. I also want to point out this. Again, they're going to say they're not allowed to have conclusions of law or findings of fact on any of these matters. And yet, what did they just do? They reported their conclusions and findings of what I testified to. That testimony was for the U.S. Senate, but they're using it to derail the contest, and I guess to build some kind of an argument that this wasn't about the Senate contest at all. And yet they're going to admit further down in their order that it is about the Senate contest. So they're meddling. All right, now I asserted that as a result of its low vote totals, the Independence Party will lose major party status in Minnesota on January 1st, 2015. Well, that is part of the evidence that had to go to the U.S. Senate. They would be interested in this, whether their elections are derailing and their contests are derailing independence and third-party movements across this country. There were a lot of third-party candidates that played a real critical role in the election of Congress this year. And we know many people in the two national parties view it as a thorn in their side. And yet it is not. It's the way, actually, you're not supposed to have those two national parties around, according to our Constitution as originally contemplated. But now, they, just like a kind of bread and circuses for the masses, they pretend that they're having this entertaining contest, and then they just take power however they do through the spending of huge amounts of money and the manipulation of elections such as this and many other ways to hedge against the power of the people. I actually believe in the power of the people. It can only be, however, realized through the United States Constitution. Otherwise, they're just a mob. They're not the citizens of the United States. It is being citizens of the United States with our rights secured and empowered to govern ourselves that we become the people of the United States. And I do believe in that. Now, Carlson, they say, further argued that the outcome of the general election and the impact on the Independence Party's status created a de facto statewide ballot question. I did not argue this. I explained why it was served on and not merely furnished to hartshorn. And I said that whether or not it is really is a side matter, and it has to do with service and making sure that this question can be considered in this contest. Now at trial, Ritchie presented the testimony of Gary Poser, the Director of Elections for the Office of Minnesota Secretary of State. Poser verified the final vote count totals, and the panel received as exhibits the 2014 State Canvassing Board Certificate, I guess II Franken, the State Canvassing Board report, and a sample state general election ballot from the November 4th election. Poser also testified the state general election ballot only listed candidates for open offices and did not include any statewide or multi-county ballot questions. And on cross-examination from me, he also admitted that he doesn't know if that's what this rule pertains to. It's not his job to know this. He's been in a few elections, and I guess this kind of thing has never come up. Well, the Independence Party has never been knocked off the ballot by an invalid election before, well, during his tenure. So maybe he doesn't know anything about this, but they still advanced it. And took a lot of time doing it, I have to say. That should have been used for actually fulfilling the purposes of the contest provision. Now, at the conclusion of the trial, December 18th, the panel closed the factual record and requested written submissions from the parties on Ritchie's request to be dismissed from the contest. Regardless of whether they requested it, I did address the entire status at that time as I knew it, and that will indicate I had no idea that this had been issued, but in fact, it was filed. This was filed December 22nd, and what it did show is that they shut down and departed from seriously the procedure required by the law. And this is a discussion of procedure. Now, the panel then issued an order on December 19th order. Notice how they call this an order. Finding that Franken received the highest number of votes legally cast in Minnesota's general election for the office of United States Senator and was therefore entitled to receive the certificate of election. The panel ordered immediate entry of partial judgment to avoid delay in the issuance of the election certificate. Now, I don't believe that this language is faithful to the actual order. In any event, they could not suspend the operation of 204C.40 subdivision 2. And that is not based on whether a panel has issued a nice order at your request, because you're Al Franken and you got the help of the Chief Justice of the Minnesota Supreme Court. That is based on whether or not the contest has been finally determined under Chapter 209. And it had not when it was issued. And and also another falseness here is this was actually signed by the three judges on the 18th, the very afternoon, and not on the 19th. It might have been entered there. Maybe that's what they mean by issue. I never received it until after December 22nd. I never got it. It was mailed to me on December 22nd. Then the panel ordered, as I say, now, the language was not present. It did not suspend 204C.40. Then they say they deferred ruling on the question of Ritchie's dismissal until it had been fully briefed. And what about the other questions? Did you ever gather evidence on that to the panel? You talk about, I testified. My testimony was not only limited to the Independence Party, but Franken's right to office because of the validity of the election. That was the contest. And so what did you do with this? And how was it supposed to be part of the election contest procedure, which you now say you defend in the Minnesota Supreme Court? Did you finally determine the contest? And I don't think you did. Or is this just something you slip in because the Supreme Court said they finally determined the contest on January 5th, one day before Franken would have been seated out in Washington, with no way to comply with the election rules at that time. Now, on December 30th, 2014, Carlson filed a notice of appeal of the December 19th order. Actually, I filed and served that on the 26th of December, it's dated that, with the Minnesota Supreme Court without proof of service on Franken or Ritchie. I may have filed that with the district court and sent it to the, I'm not sure about that, but it's not that relevant because of the fact that by this time the election certificate had already been issued. I had sent what I could to the United States Senate Secretary on the 26th. I don't know what she or they did with it, but what they got was from the state. See, that should have gone to them through the state, rather than people just sending stuff into the Senate. And I let everybody know, I let the Supreme Court know that this had happened. It was a violation of the law, and I asked them to correct it. I sought mandamus as well as appeal, and so they should have acted on it. So, and on the same day they say that I filed notice of appeal with the district court without a cost bond, $500, as if they wanted, like it was a recount, which of course this wasn't. You got to pay them $500 to get them to follow the law they're supposed to follow, I guess. But it's not really true in this case. And again, it would have been ineffective because they already issued the certificate. Now, the notice of appeal requested that the Minnesota Supreme Court reverse the judgment. Now they say it was a judgment. I'll tell you what happened. There were two judgments. The judgment of this was not filed. There was a judgment filed. It was filed and entered the 30th of December, which said that it was it caused the December 19th action on a preliminary order to be the final judgment. Then on the 31st came another judgment, which was on the contest as a whole. And so it was pretty hokey. Now, it's not a judgment. It's an order which had not been entered as a final judgment. And again, there were two judgments that I mentioned. They say I also asked that they withhold issuance of or invalidate the certificate of election. Now, clearly I didn't know that it had already been issued and was gone to Washington at this time when I wrote it on December 16th. It was shielded from me. And direct the panel to certify the record from the December 18th trial and forward it to the United States Senate. Well, they're going to argue that the Supreme Court couldn't have done anything, but they could have. They should have. It was brought to them on mandamus. Essentially, I was using mandamus to say, please let the Senate know that there's been a departure from procedure. I didn't even know that they already had their election certificate all rigged up. Then they say on December 30th, this panel issued an order dismissing Ritchie and closing the contest, called the December 30th order. Now, that was entered as a judgment, as I say, on the 31st. So they're kind of trying to confuse the record here. And they also found that the election contest related largely to the office of United States Senator, and that the panel had taken evidence on disputed issues related to the election of a senator. So, correct, my evidence, limited as you force it to be by quashing all depositions, quashing all discovery whatsoever, and holding up the record because I had to wait until this could be forwarded. The way it's supposed to be, and you'll see this in the Minnesota Supreme Court decision in the Palenti case, was that the certificate is just part of the information that's going to be forwarded to the Senate. And they're supposed to hold it till they got that information. But they let the cat out of the bag and let the horse out of the cow out of the barn, the horse out of the gate. He was gone. And that's because of this deformed proceeding, which he slickly caused in St. Paul. So correct, it was undisputed by the defendants, and it did relate to the Senate election, which seems to contradict what was written above as if the Independence Party testimony was somehow separate from the Senate election. It's all one contest. And also, the panel had taken evidence on disputed issues, they ruled, related to the election of a senator, but could not issue findings and conclusions other than that which received the highest number of votes legally cast at the election. So just to read this, they took disputed evidence on disputed issues, but could not issue findings and conclusions, which of course they did. Now, and the Attorney General has noted that none of this latter order had been appealed to the Supreme Court. So the panel also found that no constitutional amendment or statewide ballot question was at issue in the November 4th, 2014 general election, and thus Ritchie was not a proper party to the contest under Minnesota Statutes 209.021 Subdivision 3. But again, he was a respondent. On January 5th, the Minnesota Supreme Court filed an order denying the relief Carlson requested in his notice of appeal, the January 5th order. The order was issued with a memorandum to follow in order to comply with the expedited process prescribed in 209.10 Subdivision 4, which governs appeals in congressional election contests. Well, but this is false, because it could not have complied with those, because the panel filed just this preliminary order, which in turn supposedly was relied on by the governor and Secretary of State to issue the certificate December 19th, which was falsely asserted that Franken had already been selected under our law, which he was not. And in a cover letter, they falsely claimed that no pending contest remained. Then on January 15th, 2015, the Minnesota Supreme Court filed an order dismissing my appeal, in which it found I failed to remedy the filing deficiencies. January 2nd, again, I do believe that post-judgment motions can be used here in the election contest, and we're going to discuss that in this appeal. And I think that's worth it. And since the time for these motions had not expired, I believe that it was appropriate and it would have been ineffective to file this. I had learned just January 5th. At the same time I got this order from the court is the day that were filed the briefs of Ritchie and Franken's attorneys, and I read it and found out that they had already issued the certificate on the 19th. Why would I rush in, try to pay $500 for what? For what? What could they do now that Minnesota's contest provision had become another Al Franken train wreck like Obamacare? Now, on then February 4th, I filed the instant post-judgment, post-appeal motions in district court pursuant to Minnesota Rules Civil Procedure 52, 60, 62, and 59. And essentially, the heart of that is to void this and to remand it back to the panel or some appellate judges to take this evidence on this serious material and deliberate violation of the Minnesota Election Code. So, I wanted them to vacate it as void and invalidate the certificate of election issued to Franken, that it amend its December 30th order to strike certain facts and conclusions of law, which should not have been in there, that it grant a new trial, and that it stay the operation of the judgments. Carlson asserts, the panel wrote, that he contests the U.S. Senate election and that the questions voted on statewide were implicit in that election, which is true. I'm just going to stop that, and I'm going to put up the argument